Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer at Samfiru, Tumarkin in Toronto, Ontario. As you know, we hold many of these Q&A sessions. We do them multiple times a week. And the goal is to get your questions answered. Now is the time to ask your questions. We want to try to get to as many questions as possible and deal with all of your employment law issues. Just to note, so we have offices in 3 provinces in Ontario, British Columbia, and Alberta. 2 offices in Ontario, in Ottawa and Toronto. So we are across the country, and we're here today to answer your questions. And in general, you can contact us. You see the link on the screen, employmentlawyer.ca, and we'd be happy to set up a consultation and discuss your particular employment law issues and help out where necessary. As I usually like to do, I'm going to start off with an important topic, and then we'll dive into some questions. So the topic I want to start off with is the idea of what happens to employees and what are their rights when a company is sold. We see companies being sold all the time. There could be employees who work at the company for many years. There could be employees who've only worked for a couple years or 1 year or less. But nevertheless, what are your rights when a company is sold? Are you terminated? Are you owed severance? And just to put this into context, we have seen that the large chain Subway is selling their company, right? And they're selling the company to Rourke Capital. And so the question is, what happens to all the employees of Subway? Have they been terminated? What are their rights? And if there are severance rights, who is responsible for that? Does Subway pay the severance, or does Rourke Capital? And so the answer is that if employees are terminated as a result of the company being sold, those employees are owed full severance pay. Now, it could be, and this happens frequently, that when a company is sold to another company, the new company, the buying company, might offer jobs to the employees of the selling company, right? So in this case, it could be that employees of Subway, some or all, will be offered jobs with Rourke Capital. So in that case, if the job is very similar or identical to the job that the employees performed before for Subway, then typically those employees would have a duty to accept that job with the new company, with the buying company. Now, often that doesn't occur. There could be jobs offered with the new company that are very different pay, different hours, different positions, different work location. In that case, the employee does not have a duty, unless they want to, accept the position with the new buying company. And in that case, the employee is considered terminated and they're owed full severance. The selling company, being Subway, is on the hook to pay that full severance, not the buying company. Okay. Now, if this employee does not want to accept the job, and you don't really have a good reason, because the new job with the new company is a job that is very similar, you're getting paid the same, your duties are the same, work location is the same, but you just simply don't want to accept it, you would probably be owed severance, but it would only be your minimum entitlements as opposed to your full severance. And that's what you'd be entitled to under our provincial legislation. Okay, so I realize that's a topic that is a bit dense, but I gave a summary of what happens when that occurs. When there's a selling company and a buying company, a company's being sold, what happens to the employees? Are they owed severance if they're offered a new job, or are they owed severance if they're not offered a new job? So if you have any questions, any follow-up questions on that point, feel free to post it in the chat. Okay, let's dive into some questions here. So for those of you just joining us, my name is Jeremy Herman from Samfiru Tumarkin, and I'm here to answer in the time that we have, next 25 minutes approximately, as many employment questions as possible. So feel free to take advantage. So the first question we have is from Tina on YouTube. And Tina says, I work for a nonprofit organization for the past 4.5 years. We're government funded. I'm employed by the organization, but sign an employment agreement each year. If I'm not renewed next year, am I owed severance? The simple answer is yes. You would typically be owed severance. Now, the issue becomes a bit complicated if you're actually terminated in the middle of a contract, or if you're terminated at the end of a contract. So if, let's say, you're supposed to work until September of 2023, according to an agreement you signed, and the company terminates you in August of 2023, let's say a month prior, then you will be owed certain damages as a result of breaching that contract. If they terminate you at the end of the contract in September of 2023, then you would probably still be owed, severance in that case. And we're going to get into how we actually calculate severance. And so let's do that now. It's important that we actually understand that. We talk about what is severance, how much is full severance pay. So you should understand what factors are used to determine how much severance you're owed. So the way we look at that is we look at factors such as your age, your length of service, the position you were working in, how much money you were earning, and generally speaking, the availability of similar employment opportunities in the market. Based on those factors, a reasonable amount of severance is calculated. Okay, so some people think severance is 1 week per year, 1 month per year, 2 weeks per year. All of that is really nonsense. Severance is determined not based on an algorithm, but based on those factors that I just cited before. A very helpful tool that we have is called the Pocket Employment Lawyer. And part of that Pocket Employment Lawyer tool is what's known as a severance pay calculator. Now, the severance pay calculator is free. It's anonymous, so feel free to use it. If you've been terminated, you can use it. If you haven't been terminated and you just want to see what severance entitlements you have in the event that you are terminated, you can use this tool. Again, the severance pay calculator, and it will ask you all of these questions. It will ask you your age, your length of service, what company, what industry you worked in, how much money you were earning, etc. And it will spit out a calculation of how much severance you would likely be owed. So take advantage of that. We saw it on the screen a minute ago. Go to pocketemploymentlawyer.ca and you should find our severance pay calculator. Okay, we have a lot of questions rolling in, which I'm happy to see. Let us get to some of those. Okay, so let's get to a question from Tanya on YouTube. Tanya says, does the Department of Labor help assist with lost wages due to work injury? So if you're talking about the Ministry of Labor and you're owed I believe that's what you're talking about, Tanya. The Ministry of Labor does deal with wages that are outstanding if they're not being paid to you. So you can contact the Ministry of Labor. If you want a consultation with our firm about those issues, you can do that as well. And again, contact us at help@employmentlawyer.ca and we can help you. But generally speaking, if you are owed wages, then the Ministry of Labor will help you with that. Yes. Okay, good. See, Tanya asked a question. She got an answer. So I'm hoping to be able to answer more questions like that and get to all of them. So the next question from Carol Ann on YouTube says, I just want to confirm the timeline an employer has to put an employee back on a schedule after a long sick leave and has given notice to come back with an accommodation. It's been over 7 weeks. So there's no strict timeline, but generally speaking, your employer does have a duty to accommodate you, especially if you've provided medical documentation indicating what kind of accommodation you need. So if you get a note from your doctor and that note says that you need, certain breaks during the day, or you need to work part-time hours, etc., whatever the case might be. Maybe you need a certain kind of desk or chair, depends on what the nature of your medical issues are. But if you have that note, that's very powerful from the doctor, and you have to provide that to your employer. You should do so immediately, and your employer has a duty to accommodate you. If it's a very complicated accommodation, perhaps your employer does need some time to work out how they're going to go about accommodating you. But 7 weeks is starting to sound like a long time, and I do urge you to contact us, and we can look at all the other factors, all the other circumstances involved with your situation, and provide further advice. But great question. Just to summarize, yes, your employer has a duty to accommodate you. They have to do so swiftly, and the more medical documentation you have, the better. Okay, let's move on. We have a question from Sam on YouTube. What advice would you provide to a candidate navigating the tricky situation where an employer intentionally ghosts a candidate only after receiving their credentials? What is the purpose of this? Okay, Sam, so it doesn't sound like you're talking about a situation of an employee and an employer and that employee being terminated or issues with that employer while working there. You're talking about a situation where an employee is, or a prospective employee rather, is trying to get a job with a certain company, and the employer just does not answer them after a certain time in the recruitment and selection process. So if I understand that correctly, you can't really do much. That's the honest answer. If the employer does not want to move forward with the rest of the recruitment and selection process, with the interviewing, etc., then they're within their right to do so. It's a whole other can of issues when there's possibly discrimination that goes on. That's another issue. But assuming that didn't occur, then generally speaking, you should continue just sending out as many applications as possible, looking for a job within your industry. Okay, let's move on to other questions here. What do we have? Okay, so I think I'm caught up with questions at this point. Now let me talk about another important topic, and then we're going to answer more questions at that point. So the other important topic that is very common, I just spoke to someone about it in a similar situation today, is the issue of employees versus independent contractors. So there's a lot of misclassification that goes on, and that is where an employer will try to classify a worker or workers as independent contractors and not as employees, even though they really should be employees. And the reason why the company or the employer does that is to essentially avoid obligations that they would have under the law to employees. And so if the employer can say, well, hold on, these aren't employees, they're independent contractors, they are trying to get out of those obligations that they have, obligations such as paying certain entitlements during employment, paying for severance if the employment ends. And like I said, this is a very common issue. We deal with cases like this all the time. And really what happens is the law looks at the actual situation, all the facts, to determine, is this worker really an employee or a contractor? So I have people ask me all the time, well, what if I sign a contract that says explicitly, I am an independent contractor? Doesn't matter. You might still be an employee according to the law. What happens if you invoice the company? Doesn't matter. You might still be an employee according to the law. So those things will be taken into consideration, perhaps, that you invoice a company, that you signed a contract. But really what the law looks at is how much flexibility do you have over your work, over your schedule? Do you provide your own tools or equipment to do your work? Do you pay external helpers to do the work? Do you work with a team? And essentially how much control you have over the work in general. That is really the key factor. and this is again a dense topic, and we're just skimming the surface. But there's another category known as a dependent contractor, and that's someone who falls somewhere in between independent contractor and employee. A dependent contractor is still owed severance. So really the message that we want to convey is that most of the time you're an employee or at least a dependent contractor. There are some situations where a person might actually be an independent contractor according to the law, but don't just assume you are because you signed an agreement that says you're an independent contractor or you invoice a company. You might still very well be an employee. So please contact us if you have further questions on that issue, or if you are facing that kind of situation. You can contact us again at help@employmentlawyer.ca. And we have tons of resources on this topic as well, which you can find if you go to employmentlawyer.ca. Okay. So we have another very good question from Jordan on Facebook. And Jordan says, if my employer gave me a layoff form, do I have to sign it? Great question. No, you don't have to sign it, Jordan. So sometimes people use the word layoff to mean termination, but they're really distinct things. A layoff is usually considered a temporary layoff. It may not be a termination yet. Your employer is just temporarily laying you off for some reason. Could be, we see all the time, a shortage of work. If that is the case, it is likely considered a constructive dismissal. You do not have to sign that. You don't have to agree to the layoff. And you would be owed full severance if you do not agree to it and your employer still forces it on you. So I use the term constructive dismissal. Very important topic. Let's go into it a bit. So a constructive dismissal is essentially where your employer changes in a substantial way key terms of your employment. So they are not actually terminating you outright. You may not be provided with a letter that says you're being terminated effective today, but you are being told that you're being laid off, or you're being told that your hours are being cut, or you're being told that your pay is being cut, or your employer is telling you have to work at a different job location. All of those things are substantial changes to the terms of your employment, and you don't have to accept those changes. You don't have to sign an agreement that you're accepting a change like that. And really what you should do is you should contact us right away if you're being, if your hours are being cut, or if you're being asked to sign a layoff notice, or whatever the case might be, because you have significant rights in that event. And again, you could be owed as much as 24 months of pay, which is your full severance, depending on the factors we talked about earlier, your age, your length of service, your position, etc. You could be owed your full severance in that case. Now, if you don't act quickly, you could be running into some trouble. So, Jordan, if your employer sends you a layoff notice and you take too long to respond, you don't do anything about it, then your employer might say, well, you've agreed to it. Even though you didn't sign it, you have agreed to being laid off. So that's why you have to act very quickly in that case and challenge what your employer is imposing, and we can help you do that. So I hope that answers your question, and if you have a follow-up, let me know, and we'll go into other questions now. So we have a question from Juanita on YouTube. Can an employer restrict you from working another job in your off hours? So a bit of a complicated situation. It depends. Usually, yes. There are often covenants or clauses in an employment agreement that says you're dedicating all your time to working for the company that you work for, and you can't go work for another company. But it really depends on what you negotiate. So sometimes an employer will be okay with you working for another company so long as it doesn't create competitive issues, or it doesn't create scheduling issues, etc. Typically best to be upfront about your employer about that. Tell them that in your off hours, you're working at another location, or you're working for another job. We see this, it's common in certain industries. Could be, for example, a nurse. She or she might have a gig at a certain hospital, and the nurse might also work at another hospital or work at a doctor's office, etc. And that might all be fine, but best to keep all employers in the know about that, just so that you don't run into any problems. So again, to summarize, it really depends, and it also very much depends on what your employment agreement says, right? So we'd have to look at the employment agreement you have with one employer, the employment agreement you have with the other employer, and see if there are any issues that are created with you working at more than one job. So I hope that answers your question. If you have a follow-up, again, please post it in the chat. Okay, so Sam wants to know, as a follow-up, I think we were talking about independent contractors versus employees. What other media do we have? So you can absolutely find other media on this on our website. Go to employmentlawyer.ca. We have a wealth of information on this issue of contractor versus employee versus dependent contractor. And again, it's a in-depth topic, and it's good to learn about it, especially if you think it pertains to you and issues that you're dealing with your employer. Okay, let's see if we have other questions here. So Melissa on Facebook asks, I work for a doctor. When hired 2 years ago, I was guaranteed 30 hours a week. Today, my hours have been cut to 20 hours a week. If the doctor doesn't work, I don't work. I'm available all the time. What can I do? Great question. This is a good example of what we talked about earlier, the idea of a constructive dismissal. So what appears to be here is a substantial change to Melissa's hours of work. So, Melissa, if you work 30 hours a week and now your employer, the doctor, is saying we only have 29 hours for you. So you lose 1 hour. Potentially in that case, you may not have a strong constructive dismissal case because it may not be considered a substantial change to your term of employment being your hours of work. But if you're being cut from 30 hours to 20 hours, that is a very significant cut of 1/3 of the time, 1/3 of your hours. And so you absolutely have rights here. You can treat this as a constructive dismissal. And again, we can help you do that, work with your employer and leaving your job and obtaining the severance that you're entitled to. You have to make sure that you do this properly. And so that's why we always ask people who are facing this situation, employees, to contact us, and we'll work you through all the steps so that it's done the right way. But yes, if your hours are being cut so substantially, then that is a constructive dismissal. Even if the doctor just, doesn't work those hours and say you have no work to do, if you were guaranteed a certain amount of time to work and now you don't have those hours anymore, then that is a significant change to the terms of your employment. Okay. Let's dive into, as we wait for some more questions, another topic. Again, if you're just joining us, my name is Jeremy Herman. I'm an employment lawyer at Samfiru Tumarkin in Toronto, and we are here to answer as many questions as you have on employment law issues. We've dealt with many topics so far, and I'm happy to answer as many questions as possible and around the 4 or 5 minutes we have remaining. Okay, let me talk about another topic. So we see we talked about the body known as the Ministry of Labor earlier on in this session, and new news is the Ministry of Labor is proposing to introduce new regulations that deal with employees who work in very hot environments to better protect those employees. So there's legislation known as the Occupational Health and Safety Act. Essentially, what that legislation says is that an employer has a duty to provide a healthy and safe environment for employees. Some employees work in very hot climates. You could be working as a construction worker, for example. In the summer, you might be dealing with a heat wave. And so we need regulations that specifically deal with having to work in very hot environments. And the Ministry of Labor is proposing new regulations on that. So that's an important piece of information. And really the concern that the Ministry of Labor has is that if you work in these environments, it's hard for an employer to satisfy their duty that they have to employees to provide a healthy and safe environment, because the heat could lead to heat-induced occupational illnesses, and it could lead to death in some situations. So there's certainly issues there. Let's dive into more questions that we have. So we have a question from Juanita, a follow-up. What about workplace training? Should the time spent in training be paid hours? It depends. Sometimes yes, sometimes no. There are some situations where if you work for an employer rather, that the time spent training before you start the job will be unpaid. Often we see that it is paid. So again, context dependent. Another question we have on YouTube from Brennan. Brennan says, can an employer stop paying RRSP benefits? So that's a great question as well. So it depends in what context. We'll talk about two different situations. One situation is if you are working for a company, you're entitled as part of your compensation package to RRSP contributions from the employer. In that case, if your employer stops paying those, then that is changing a substantial term of your employment. Going back to what we talked about earlier about a constructive dismissal, that could indeed be a constructive dismissal. It again will depend on how substantial those contributions are from your employer. And if they are very substantial, then it could be a significant change to the terms of your employment, and therefore a constructive dismissal of your employment if your employer is stripping away the contributions to the RRSPs. Another situation, I said we talk about two. So another situation is what happens if you are in fact terminated. It's not that you're just working for a company and then they stop paying RRSP benefits, but you actually are being terminated and you're owed severance. And if you're owed severance, then that severance package should reflect your entire compensation package. So it should reflect your base salary. It should reflect your benefits. It should reflect your RRSP contributions you receive. Perhaps you receive a phone allowance or a car allowance. All of those elements of compensation should be continued throughout the severance period. For example, let's say the law would determine that you are owed 12 months of severance. So 12 months would not only be your base salary, it should also be benefit continuation. If you have health and dental benefits, those should be continued for the 12 months. Again, if you receive contributions from your employer, those should as well be continued throughout the entire severance period. There are some cases where there might be a policy, for example, with respect to RRSP benefits or a pension plan, and those policies might say that those elements of compensation are not continued throughout the severance period. But generally speaking, they should be. So Brennan, I hope that answers your question. That is it for today. We got to many, many questions. We talked about several important topics, and I hope it was very helpful. Thanks for joining us, and I'll be with you again soon. Have a good day.